November 16th, 2021. It is a time for our regularly scheduled business meeting. Would the other commissioners join me in reciting the Pledge of Allegiance? Thank you, commissioners. I would note for the record that all 5 commissioners are present today in the Bollinger Room, so we do have quorum. Time now for public comment. I understand we do have one public commenter in the room. Please come forward and state and spell your name for the record, please.
Good morning. My name is Shannon Heim, H-E-I-M. I'm the Director of Regulatory Counsel for Northwestern Energy, and I am here to offer a very brief comment about item 6 on your agenda today. FERC docket RM 21-17 is an advance notice of proposed rulemaking, which represents the first very small step in a long process of actually updating the FERC rules if they choose to go down that path. For example, yesterday, the FERC staff led a technical conference on these issues with reply comments due no later than November 30th. If FERC decides to move forward with any transmission planning reforms, and what they're looking at is perhaps a proposed holistic view of transmission planning, this is a huge undertaking. It would need to issue a notice of proposed rulemaking identifying those specific rule changes. Following the issue of that notice, there will be a lot of substantial process, more workshops, a lot more discussion about exactly what are those rules, how will they apply to industry, how will they be implemented on the state and the federal basis. Northwestern Energy is closely monitoring this docket. We're keeping an eye on it. We did not file initial comments, and we will not be filing reply comments. Simply stated, we didn't find value in responding at this point in the process. I realize there are some extraneous comments in the record that are off topic. I would urge you to disregard, frankly. We deeply appreciate the volume of really important work on your agenda and the scarce resources that you're dealing with. And we would urge you to keep this in mind as you are allocating your legal resources in particular. And with that, that's all I have. Again, we really appreciate everything that you're doing and the volume of work on your plate. So we thought we would offer just this brief comment. Thank you.
Thank you, Ms. Heim. Any other public comment from the room? Seeing none. Any commenters online? Seeing none. There are no changes to the agenda this morning. So let's move into our action items. Action item number 1 is approval of the commission minutes for the week of November 8th, 2021. Is there a motion or discussion? Commissioner O'Donnell?
Mr. Chairman, I moved adoption of the minutes.
Okay, we have a motion to adopt the minutes, seconded by Commissioner Pinocci. Discussion or changes to the minutes? Seeing none, all those in favor of adopting the minutes for November 8, 2021, signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Being no opposition, the minutes are adopted unanimously. Let's move into our work session. Work session item number 1 is docket 2021.06.091 Montana Dakota Utilities Company application of MDU for authority to implement a fuel and purchase power cost tracking adjustment. We're here to discuss and act on MDU's filing. Mr. Fink.
Good morning, Chair Brown, Commissioners. Included in your packet should be a draft final order on this matter. On June 17th, 2021, Montana Dakota Utilities filed its application with the Commission for its fuel and purchase power cost tracking adjustment for the May 2020 through April 2021 tracking period. As you'll recall from the June 29th work session, the Commission approved interim rates of Montana Dakota Utilities application to be effective July 1st, 2021. On July 8th, the MCC petitioned to intervene in this docket and was subsequently granted intervention. The MCC issued data requests on August 31, 2021. Thereafter, the MCC did not submit intervener testimony or request additional process. Staff has analyzed and reviewed the application and finds the request supported. Staff recommends approval of the draft final order before you today, and myself and Lucas are available for any questions. Thank you.
Thank you, Mr. Fink. Discussion or a motion? Vice Chair Johnson.
Move we approve staff recommendation, Mr. Chairman.
And all right, Vice Chair has moved to approve staff recommendation, seconded by Commissioner O'Donnell. Discussion? Discussion? Seeing none, all those in favor of the Vice Chair's motion signify by saying aye. Aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Mr. Fink. All right, let's move to work session item number 2, which is docket number 2021.10.122 MDU, the application of Montana Dakota Utilities Company for automatic tracking adjustment for Montana and local taxes and fees to consider assigning a hearing officer. Mr. Hamilton.
Thank you, Mr. Chairman and Commissioners. This docket is the annual tax tracking adjustment that MDU files every year under statute. It's a very quick process for the Commission to review. In fact, currently, the application has not yet been filed. We have initiated this docket, though, with a protective order, which is routine. The information that our minimum filing rule requires is confidential under state and federal law. So we anticipate that the application will be filed very soon. We have flagged this docket as a potential docket to be referred out to the Agency Legal Services Bureau. As you'll recall, the legislature appropriated approximately $100,000 per year in this biennium for the Commission to utilize the services of ALSB for hearings examiners. That said, we have been in contact with the attorney for MDU. He informed me actually this morning that MDU does oppose appointment of a hearing examiner in this docket. Typically, these tax trackers are concluded without a hearing because of the very quick timeline. In fact, by statute, they are automatically effective unless the Commission identifies an error. So it's typical not to even have a final order in these dockets by virtue of the statute. MDU's concern, to paraphrase, is that they believe that appointing a hearing examiner in this docket could introduce more confusion and additional process than is necessary given the simplicity of the docket. We will have 3 in total of these tax tracker dockets, 1 for Northwestern Energy and 1 for Energy West Montana as well. Commission staff has generally flagged these as potentials to be referred out to Agency Legal Services Bureau, but of course it's entirely up to the Commission as to whether or not to use that process in this case. Staff has prepared a draft letter and draft notice of Commission action if the Commission should decide to refer this out to Agency Legal Services Bureau. Happy to answer any questions that you may have.
I have a procedural question for you. Do we need to take any action today if we're just going to decide to keep this in-house at this point?
Mr. Chairman, Commissioners, no. The default is to be processed in-house. So by not taking action to refer this out, that would effectively keep it in-house.
Okay, Vice Chair Johnson.
Thank you, Mr. Chairman. Mr. Chairman, I really dislike the concept in government of use it just because it's there. And I think that's exactly what we would be doing here. So I would concur with you, Mr. Chairman, that we simply do nothing and keep it in-house.
Discussion, Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Lucas, it would seem to me that on something basically routine like this, that it might be imprudent to use up all of our authorization that we have, saving that for more burdensome things to relieve staff time. Is that, I'm concerned that would be using up part of that valuable resource for something that we wouldn't need.
Commissioner O'Donnell, Mr. Chairman, currently we only have 1 docket referred out to Agency Legal Services Bureau for a hearing examiner purpose. So we have, I would say, considerable resources available in that appropriation left should the commission decide to spend it. There's also a natural tension between wanting to refer out substantive, burdensome dockets that involve very significant findings of fact under the standard of review under MAPPA. If you refer a docket to a hearing examiner, that hearing examiner is in the position of making those factual findings in the first instance, and those findings cannot be reversed by the commission unless there's a finding of clear error, in essence, in the process or the hearing examiner's finding. So it's not always in the commission's best interest to refer out the most substantive dockets because you may rightly decide that you would prefer to make those factual findings in the first instance yourselves. But that is the question for the commission in every instance of referring out a hearing examiner docket. Because this one is simple, it's, I would say, very unlikely to involve factual findings that would be best made by the commission in the first instance.
Mr. Chairman.
Commissioner O'Donnell, follow up.
Thank you. Thank you for helping me to understand how this resource is to be used. So basically, what if I understand it correctly, it's of more value to the commission and staff time to refer perfunctory things out to save time here for weightier issues. Is that the philosophy?
Commissioner O'Donnell, Chairman, that is one way of approaching it. It's not necessarily the best way or the proper way, especially for these tax tracker dockets. They are quite simple. As long as the information does not point to any errors, they are automatically effective, and there will be no need for a hearing or even a final order. So in terms of saving staff resources, there isn't a whole lot to be saved in this process. If that answers your question.
Well, Mr. Chairman, yeah. So what I was looking for was what the criteria is from legal staff of when to do things. You know, what's the standard type of thing. So you said that what I just suggested is one way, not the preferable way, but what is the standard that the legal staff uses?
Commissioner O'Donnell and Chairman, the legal staff has identified basically every tracker docket that is typically handled on an annual basis that requires some factual findings on the way towards a final order as a potential referral out. If the commission were so inclined, it could also refer major dockets out, rate cases, pre-approval dockets, that sort of thing. But legal generally has not identified those as candidates for referral out because of the weightiness of the issues and the value of having the commission make the findings in the first instance.
Okay.
Unless there's a motion, we'll just move on to the next business item. Okay, thank you.
Thank you.
All right, let's move to work session item number 3. This is docket number 2020.09.094, commission initiated. Mission investigation of North Star. We're here to determine whether to issue an NCA to receive information regarding the supply source of North Star's irrigation field. Mr. Ogala, I believe you are handling this matter for the commission.
Correct. How's my audio coming in?
It's quite good.
Okay, great. Chairman, commissioners, I'll be brief here. The parties are looking to narrow the universe of contested issues in the North Star docket. One that we hope is entirely uncontested is determining the supply source for North Star's irrigation field, which is located near the utility. There's been some representations that the irrigation field is being watered with supply from the North Star utility, and that water should otherwise be used only for the utility. North Star has provided documents from its operator and an engineer, essentially stating that it's impossible for the North Star supply to be feeding the irrigation field. And so we want to tee up a quick notice of commission action, establish a date certain where parties can provide competing information to contest that claim. If there's no competing information, we'll tie this one up as a uncontested issue and move about the docket. If there are claims or evidence that we need to look into, I will consider next steps at that time. The reason we're going this route instead of just assuming it's a done deal is because there are several customers in the North Star subdivision who have not been able to reach agreement with North Star on this issue. So we wanted to elevate it to a quick notice of commission action. So with that, I'll stand for any questions.
Thank you, Mr. Regala. Vice Chair, did you have anything? Commissioner Fielder.
Mr. Chairman, thank you. Just before we get into a motion, I would like to ask Mr. Rogala, as I read through this, I was a little bit curious as to whether this issue of the irrigating with sewage water on this hayfield, does that have a nexus to the rates that the customers in the North Star subdivision are paying for their utilities? Or is it completely separate? Is that hayfield owned by a separate entity? Is it a matter of the sewage is just is waste and it's just being used in another way? Or is there a connection between the rates the customers in North Star are paying and the effluent that's being distributed onto that field?
Chair Brown, Commissioner Fielder, to my knowledge, the irrigation field and the infrastructure to serve that field are not included in North Star's rate base and are not being recovered from customers. So I don't think there's a rate impact here with that field. If I were to speculate, what I think is going on here is that some of the residents in the subdivision noticed that this owned field was watering throughout the summertime with no restrictions, while right next door, their utility was subject to summer watering restrictions. And I think there was some dissonance there that kind of led to this issue becoming more elevated than what it should be. But to my knowledge, there is no customer impact here with this irrigation field.
Well, Mr. Chairman.
Commissioner Fielder.
So, Mr. Chair and Mr. Rogala, if we are to pass a motion on this NCA today, would you be able to would the commission still be able to answer that question through this docket to find out if there was, I don't know if this company is also charging, if the utility is also charging for sewage disposal and if that has a connection with the regulated entity or not. Would we be able to kind of flesh through some of those issues through this process of examination, or are we limited only to what the parties might present?
Chair Brown, Commissioner Fielder, we could issue this notice, resolve the supply issue, which is whether the irrigation field is supplied by water from the North Star supply system, and then still have the full authority to investigate any of these seam issues and their customer impact, if any. So, for example, whether the wastewater is being charged to North Star customers, but then is benefiting an affiliate of North Star that owns this irrigation field. So we'd still have the full ability to investigate those issues if we wanted to.
So, Mr. Chairman, as I understand you, then this would just simply isolate the issue of whether the irrigation water being placed on that field is potable water or good water, or whether it's effluent and doesn't impact the supply for the household use in that subdivision. Correct?
Correct.
Okay. Thank you, Mr. Chairman. That answers my question sufficiently.
All right, Mr. Vice Chair.
Thank you, Mr. Chairman. It appears to me that we have somehow managed to make an uncontested question become a contested one. The scope of the question is very narrow, and I think that the way to resolve the question is to, in fact, issue the NCA and put that to bed. And then if there are other questions about rate structure, et cetera, I'm sure that with the activity that's going on among the parties at North Star, those questions will be brought to us by the parties. So I'm very comfortable with issuing the MCA simply to address this question about whether or not irrigating that hayfield impacts supply to the residents of North Star. And I would move that we authorize issuing the MCA, Mr. Chairman.
Thank you, Mr. Vice Chair. Is there a second? Commissioner Pinochi has seconded. Discussion? Mr. Fielder?
No, thank you. My questions are answered.
Commissioner Pinochi?
Mr. Chairman, I think it's a little unclear why sewer lagoons are drained. I used to manage them, so I think I can spend about 5 minutes, maybe less, on this so everybody has a clear understanding. Sewer lagoons get full, and when they do, you have to lower the level. What you normally do is you bring in a large truck and they pump out the sewage. And in most cases, it's just really clear water. The sewage is settled to the bottom and it is delivered somewhere and disposed of. And this is expensive to bring a truck in to lower your sewer lagoons. Managing this, I try to tell the water people, the homeowners, that if you have a toilet where the valve sticks and your toilet's running all night long, if I could have 10 or 20 of those toilets going on, we're pumping water into the sewer lagoons, raising the level. Also, they have to pay for that water. So making sure your toilet doesn't have that leak can save you hundreds of dollars. But what if you have heavy rains or a lot of snow? Your sewer lagoons raise and level. And then I have to call in trucks to deal with it. A way to do this that's very economical is if you could find a neighbor who allows us to pump water in a sprinkler system and drain the lagoons that way, is a real benefit to everybody, all the ratepayers, because we can get rid of the extra water in the sewage lagoons and lower them. And if you could irrigate a hayfield, this is a tremendous benefit. In other words, I want to thank the guy who allows us to drain the sewage lagoons into his hayfield, because it saves a lot of money because we don't have to pay a truck to do it. Now, where it gets confusing is a person will say, well, that's our water. Yes, that's the water that comes through the sewer. And if you have a leaky faucet that's running all night or a toilet, you're filling up that lagoon, right? Now, this is very easy to argue. It can't possibly come from the water source that people drink because there's no water line that's directly connected from the water people drink to the sewage lagoon. There is no line. They're just simply taking the water from the sewage lagoon. But customers can get confused very easily thinking they're using our water that we drink in the sewage lagoon. There is no water line between the pump house and the hayfield. There's only a line between the sewage lagoon and the hayfield. And I want to let everybody know how lucky we are that we have a hayfield that's willing to take that sewage water because it's very cheap. We don't have to hire the truck to lower the sewage lagoon. So it's a real benefit. And I just think people need to look at it from that perspective. Thank you.
Additional discussion? Being none, all those in favor of the vice chair's motion to issue the NCA, signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. All right, Mr. Regala, I believe you're up for the next one too. Let's move to work session item number 4. This is docket 2021.09.111 Northwestern Energy, Northwestern's QF1 power purchase tariff update, to make a substantive decision now on Northwestern's motion for reconsideration. Mr. Regala.
Thank you again, Chairman, Commissioners. Staff put together a brief memo after we deferred the work session to this week. Essentially, the point of the memo is that the Commission is not subject to judicial standing requirements. Rather, we're subject to basically whatever the legislature enacts for proceedings before the commission, that kind of sets the table for what parties are allowed to participate before the commission. And based on what the legislature has passed, the commission also has rulemaking authority to tailor the confines of those requirements. And so we've adopted a intervention regulation, which establishes a basically a test to determine whether the party has the ability to participate in a given proceeding. That's the direct and substantial interest test. And as we noted in our staff memo, we believe that Greenfields has satisfied this test based on its representations that it's currently in discussions with Northwestern on developing a project that would take service under the QF1 tariff. However, staff doesn't have a strong recommendation here because we also think that Northwestern makes a reasonable point that based on Greenfield's current FERC form 556, it would not take service under the QF1 tariff. But we think on balance, it makes sense to grant intervention here and let a QF1, a potential QF1 participate in a QF1 docket. So with that said, I'm available for any questions.
Thank you, Mr. Regala. Vice Chair Johnson.
Thank you, Mr. Chairman. Mr. Chairman, I want to get this procedurally right. We have this two-step reconsideration thing. The intent of the motion I'm about to offer is to deny even reopening the docket for reconsideration. So we won't have to go through discussion of merits of the motion. Were we to reconsider Mr. Regala, would that work? Can I make a motion in that way to simply deny the request to reopen this docket for reconsideration?
Chair Brown, Vice Chair, I think that works.
All right, and I would offer that motion, Mr. Chairman.
Can I get a clarification, Mr. Regala? My understanding that, I don't know, was it, well, no, on November 8th, what we did was we granted the motion for reconsideration, did we not? And then deferred a decision on the merits of the reconsideration. And isn't that what we're handling today, Mr. Regala? Am I off on that?
Yeah, Chair Brown, I forgot about that. So I could go back and check the minutes, but subject to check, I think you're right. I think we opened up reconsideration because we had a back and forth between commissioners on what exactly the deferment would do in that stage. And I think Commissioner O'Donnell pulled his second on the initial motion to deny reconsideration because we were going to discuss the merits. So I think, assuming that's all correct, the way to do it would be to assume we're in that second stage that Vice Chair Johnson noted and say the motion is to deny reconsideration and on the merits and go from there.
All right, based on that analysis, Mr. Chairman, and subject to check, I will move that we deny reconsideration and admit Greenfield as an intervener.
Thank you, Mr. Vice Chair. Is there a second for that? Commissioner?
Mr. Chairman, I will go ahead and second the motion.
All right, so we have a motion that's been seconded by Commissioner Fielder. Discussion. Let me just start out by saying that indeed, my recollection was correct. I'm looking at the minutes. So Vice Chairman Johnson granted Northwest Energy's motion for reopening consideration. I second the motion. Commissioner O'Donnell dissented. Then the commission deferred considering the merits of the Northwest Energy and directed staff to further brief the commission, which has all been done at this point. Discussion, Commissioner Fielding.
Mr. Chairman, I expressed a little bit of this the last time we brought this up. I'm not real comfortable with how loose our process is or our precedent is for allowing parties to intervene or to join onto a docket, but I think we're bound to precedent unless we have some very clear explanation for a departure from precedent. And I would suggest, recommend, and hope that we could tighten this up a little bit through rulemaking, just simply because I've seen so much what I would consider to be abuse of parties coming in and clogging up the wheels of justice with a number of people that really don't have standing, making a very, very long stretch to claim that they have standing. So I'm supporting the motion today, but I hope the commission can move towards tightening up our process and our criteria for allowing that access to parties to intervene.
Thank you,
'Cause
Commissioner.
it sounds like some of the explanations given were fairly loose to me.
Thank you, Commissioner Fielder. Commissioner O'Donnell.
Thank you. Basically, I oppose the motion for the same reasons that Commissioner Fielder just enunciated. I think that if we allow interveners who are not currently involved in a case, then we're opening up too wide right here, and it's very imprecise. Although I see the arguments on both sides, both of them are credible, that I would oppose the motion, Mr. Chairman.
All right. Thank you, Commissioner O'Donnell. Further discussion? Further discussion? Let me just piggyback on Commissioner Fielder's comments. If there was ever a situation where the party is right on the borderline of showing they have a substantial and direct interest, I would say it's this one, because Greenfield has represented in public filings that it will not interconnect to Northwestern system, and it doesn't plan to sell its power to Northwestern. But that being said, is that I have reviewed staff memo. I've gone back and looked at some of the case history on intervention and standing before the commission. Maybe one of the disadvantages I have as a commissioner is that I do have legal training, and so I'm very familiar with constitutional standing principles, and often import those into these proceedings. But clearly the case law provides that in regulatory proceedings such as this one, concept of standing and participation are far more loose than the judicial standing standards. And so, as Commissioner Fielder pointed out, we did start down the path earlier this year of looking at revising our intervention standards. I indicated when that matter came before the commission that I am certainly inclined to tighten up participation in our proceedings, maybe to make it more in line with constitutional standing and participation. I do have some concern that if I were to go and vote against the vice chair's motion at this point, that the commission could find itself before a district court under an arbitrary and capricious and failure to follow precedent. And so reluctantly, I'm going to support the vice chair's motion today, even though I think there is certainly good argument made by Northwestern Energy in this matter that Greenfield does lack standing. Additional discussion? All right, all those in favor of the vice chairman's motion, which would be to deny in substance Northwestern.
Mr. Chairman, before that, I want to say that I have listened to your statement very carefully, and I will defer to your assessment of the situation and support the motion.
Thank you, Commissioner O'Donnell.
Even though I think, as I agree with all that you said, that Northwestern has made a very good case. It's right on the edge. It's a coin toss type of thing, but Mr. Chairman.
Thank you, Commissioner O'Donnell. So just to clarify, if you vote for the vice chairman's motion, we are substantively denying Northwestern's motion for reconsideration. All right, all those in favor of the vice chair's motion signify by saying aye.
Aye.
Aye. All those opposed signify by saying no. Seeing no opposition, motion carries. All right. Let's move to work session item number 5. This is commission initiated. This is to update the commissioners on commission travel. To have commissioners who have traveled, provide an update to the public on the purpose of commissioners' travel in conformance with the agency Blue Book policy on the same and how the same benefited the agency. So I'll do this in order of seniority here. So, Mr. Vice Chair.
Thank you, Mr. Chairman. Just returned from NARUC's annual meeting in Louisville, Kentucky. I would, Mr. Chairman, make a general observation with regard to commissioners' participation in NARUC meetings, and that is the opportunity that is presented over that 3-day period to network with fellow commissioners and industry folks from around the country is very valuable in a broad sense. The quality of the educational panels that we were able to sit and listen to is uniformly very high with NARUC. They do an exceptional job in putting those educational efforts together. So from a kind of 30,000-foot generic sense, the networking and the continuing education is very beneficial. In terms of my individual activity there, 2 things in particular I'd like to share with the commission. First, had a fairly lengthy meeting with representatives from the National Council on Electricity Policy. They are a NARUC affiliate and a National Council of State Legislators affiliate. So they are in both the legislative and the regulatory world in terms of their activities. They are very interested in being a full partner with us in terms of trying to be a catalyst, if you will, through NARUC to create an ongoing dialogue, probably at the regional level, with CSG, NCSL, and NARUC to address this question of regulatory and legislative relations. As I visit with colleagues from across the country, it is almost universal that regulators feel there is a very real need for enhanced communication between the regulatory and the legislative sectors, and in fact, adding to that, after the NARUC meeting, also the Consumer Council side of that now kind of 3-part equation. So I found that very beneficial. We've got some specific steps we're going to take in terms of ongoing communication with NCSL and Council of State Governments, and would hope that we're going to see some specific well, in fact, we have a slot in the February meeting at NARUC for a panel dealing with the legislative and regulatory relations. So found that to be very beneficial. Second, I had opportunity to sit with for Commissioner Christie at the board dinner. We had extensive conversation with regard to the impact of PURPA and the newly revised rules on Montana. He was very much interested in the fact that a stated intention of at least some commissioners to re-revise those PURPA rules would have problematic impact on us, and has requested that we submit to him in writing our contention that we really need to preserve those recent revisions that were made in the PURPA rules by FERC. I've found that to be a very positive response from him in terms of that conversation. He certainly was very much engaged and interested, and not the least bit dismissive of our concerns, Mr. Chairman. So in the interest of brevity, that would represent the highlights of my time at the NARUC meeting.
Thank you, Vice Chair Johnson. That was very informative. Commissioner O'Donnell.
Thank you, Mr. Chairman. Yeah, having attended the same meeting, and while Commissioner Johnson was meeting with FERC Commissioner Christie, I was having nice dinner conversations also with FERC Commissioner Danley, who impressed me greatly as a person of great intellect and curiosity about things, very, very down to earth. In one of my questions, in one of the forums where he was present, I thanked him for being at the NARUC conference its entirety, not just a brief visit, and asked him if the FERC Commission looked at state commissioners as a top-down approach or bottom-up, whether or not they were listening. And he, consistent with what Commissioner Johnson was told, it's a very bottom-up information system. They really do care very strongly about getting information from states. So that relates to our item number 6 on here as well. As chairman of the subcommittee of Electricity Committee of Carbon, Clean Coal and Carbon Management, I co-hosted a panel that was representatives of the University of Kentucky and all the amazing work that they're doing in innovation in the whole fossil fuel area. And it was very, very impressive on that. There was, at the end of the conference, there was a separate meeting of all 5 FERC commissioners, and I think is it 12 state commissioners, Chairman, Mr. Johnson? 12, yeah. 2 representatives, commissioners from each region, and the Western region is representatives are a commissioner from California, from CAISO, and Commissioner Christine Raper from Idaho, who I think will very ably represent the interests of the West. I invited her to visit this office and to allow us to understand what her expectations are in terms of what the committee is to achieve in relative to transmission issues across the whole country. And of course, that has a lot to do with item number 6 on the agenda today. She's very enthusiastic about doing that. And I've contacted the chairman to follow up on that with not just her with this commission, but with other interested parties from the transmission providers in the state and anybody else who might have input on this issue. Apparently, the goal is to result in federal legislation or rules from FERC having to do with transmission that could very well affect Montana. Mr. Chairman, those are the highlights that struck me.
Thank you, Commissioner O'Donnell. Commissioner Pinochi.
Thank you, Mr. Chairman. I did not attend the latest NARUC meeting in Kentucky, but I did attend a rate school training in Albuquerque, New Mexico, put on by the University of Albuquerque, or sponsored by the university. And in that rate school training, I was looking to gain more knowledge about the high efficiency power lines and what they save in line loss. I think it's important to note our very own staffer, Gary Duncan, was an instructor and it was a real honor to see him as an instructor at that rate school. Now, some of the interesting things that happened is during the rate school training, which is basically 8 hours a day for a week. It's very intense. And I was able to get a better understanding of rate school. I wanted to attend this school over a year ago, but we had to face COVID where it was canceled. So this put me behind. So I had to attend this year. But they had an entire class studying the amount of electricity that's lost in a line that just evaporates into air. And people don't have a very good understanding that a good amount of electricity just simply leaks out of the line. The new high performance power lines cut that by a third. And we have this wonderful opportunity where Northwestern Energy is installing high performance power lines in Monarch. And we've done a press release before the rate school happened, where there's going to be a $440,000 a year savings. So I was able to present this in the class, and the instructor was caught off guard because they're so focused on line loss with the older model power lines or conductors. They're not used to seeing the high performance formulas. As a result, the instructors there are considering changing future classes to reflect that there can be savings of a substantial amount with the high performance power lines. Thus, the school will leave that open for encouragement to install these type of lines. So I think that made it pretty darn exciting. And it was real important for me to be there and attend to get this training, because we have opened an energy efficiency docket where we're promoting energy efficiency here in Montana. And to understand line loss and be trained in it, I think will make me a better commissioner, and I can pass on that training to fellow commissioners in this commission. I am preparing a report on this, and I'm waiting for a certificate that I completed the course, which I think is coming in the mail. Mr. Chairman, thank you.
Thank you, Commissioner Pinochi. Commissioner Fielder.
Thank you, Mr. Chairman. My travel as of late has been limited to my duties as presiding officer over the L&L site services application. We had a 5-day hearing in Missoula, October 18th to the 22nd. My expenses were limited to some round trip mileage from my home to Missoula and 5 nights motel and a small stipend for per diem for some meals. So the total was $670.66. The dates were October 18th to 22nd. And I believe that my presence there benefited the agency. Although we could probably do these things remotely, there's a lot that's lost in remote transitions because you can't see the body language, you can't see the gesturing, and there's a lot of that the presiding officer needs to read when legal counsels are trying to do their back and forth or make their cases and so forth. So I appreciated the opportunity to be the presiding officer there. I think it was a good hearing. It was intense, and I think it was. I was very impressed with the level of participation and the quality of the testimony and the legal counsel's work. So, thank you, Mr. Chairman.
Commissioner O'Donnell.
Yes, Mr. Chairman, I neglected to add something very important, is that at NARIC, resource adequacy and resource reliability are very, very much in forefront of conversation. And I discussed with as many people as I could that the particular situation in Montana is that if we experience another polar vortex or something that brings temperatures down into the 45 degrees below zero range, and with a shrinking market of available power for purchase, that if something, the same thing happens simultaneously in Washington, Oregon, polar vortex, or something happens in California, and we have to go to the market, that Montana may very well be outbid. And that would mean that people in Montana would die. It's not a matter in more temperate climate areas of the country that rolling blackouts are simply an inconvenience that you have to deal with. In areas like Montana or in Arizona, where it gets extremely hot, if there is no ability to moderate temperature, then the results are life and death issues. So I think that issue is being looked at seriously nationwide, and I tried to bring that to focus that specifically on the needs of Montana, Mr. Chairman.
Thank you, Commissioner O'Donnell. And the chairman myself states that I haven't done any commission paid travel. Okay, thank you, commissioners. Those were very interesting, informative updates. I think this is actually a really good exercise for the agency to go through, to be honest, because I appreciate hearing what each of you are working on. All right, let's move to work session item number 6. This is FERC Advance Notice of Proposed Rulemaking, docket RM 21-17. FERC Advance Notice of Proposed Rulemaking on Electric Regional Transmission Planning, Cost Allocation, and Generator Interconnection. Discuss filing comments and direction to staff. And this is a biggie because we have Will presenting. We have the big boss. Morning, Will.
Good morning, Mr. Chairman, Commissioners. So as you've heard, on July 15th, FERC issued an advance notice of proposed rulemaking in docket RM 21-17. The docket is titled Building for the Future Through Electric Regional Transmission Planning and Cost Allocation and Generator Interconnection. Because this is an advance notice of proposed rulemaking, FERC has not identified any specific proposed new rules or changes to existing rules. Instead, the ANOPR discusses conceptual changes to existing processes in 5 categories: regional transmission planning, regional cost allocation, generator interconnection funding, generator interconnection queuing, and customer protection. FERC sees a need to review its existing jurisdictional transmission policies because of transformations in the electricity sector, including a trend toward greater capacity and energy production from wind and solar resources located far from loads. At a high level, FERC seems to be interested in a couple of key issues. First, whether current regional transmission planning and cost allocation processes appropriately consider the transmission needs of anticipated future generation. FERC expresses a concern that most transmission system expansion seems to occur as a result of the generator interconnection process, which focuses on the system impacts of individual generators and may miss potential efficiencies that could be achieved through economies of scale. FERC also seems to be concerned that current cost allocation methods may not always allocate costs in a way that achieves previously established cost allocation principles, including that costs should be allocated commensurate with benefits received. Here, FERC seems to be concerned that the participant funding method in particular may fail to adequately recognize reliability benefits that accrue to the system as a whole, which is to say other users of the transmission system. The National Association of Utility Commissioners, NARUC, submitted comments on the ANOPR on October 12th. Generally, NARUC's comments do a good job of representing the interests of state regulatory commissions by emphasizing the importance of protecting jurisdictional retail customers from cost shifting and incentivizing efficient siting decisions by developers. A couple of Montana QF developers also submitted joint comments on the ANOPR. The Montana QF developers generally encourage FERC to extend the scope of the generator interconnection and cost allocation policies to include PURPA QFs and to restrict state authority to determine cost responsibility. The QF developers' comments generally disparage this commission's implementation of PURPA, particularly with respect to the treatment of interconnection-related network upgrades, In staff's view, the comments misinterpret existing commission rules as well as FERC rules and orders. So that brings us to the purpose of this work session, Mr. Chairman, which is to discuss and decide whether this commission would like to submit comments on its own in the ANOPR. As I said, NARUC's comments, I think, do a pretty good job of representing the diverse interests of the various state commissions around the country in this matter. And so the commission could simply sort of rely on that representation and not submit separate comments. If the commission would like to submit its own comments, staff would recommend keeping those comments brief, leveraging from what NARUC has already done. And that is in part in recognition of limited staff resources and the work that would need to be put into that. Also, there's no need to really reinvent the wheel on what NARUC has said. There is this issue about the addressing the comments of the QF developers. I think staff in some ways is its instinctive response or reflective response is to want to defend the commission's past decisions with respect to PURPA implementation. It's maybe important to note, however, that the ANOPR does not address PURPA at all. And so there's a question of whether we should elevate the QF developers' concerns in a response. If the commission decides it would like to submit comments, staff will prepare a draft and present that to you at a work session on November 30th. And November 30th is the deadline for submitting comments. That's all I have, Mr. Chairman. I will turn it over to Zach if he has anything to add other than that. Otherwise, we are available for any questions you have. Thank you.
Mr. Gallo?
No additional comments, Chair, but available for any questions on what or where we go from here.
All right, thank you, Mr. Abdallah. Vice Chair Johnson?
Thank you, Mr. Chairman. End by simply offering a motion that we do in fact submit comments with regard to the advanced NOPR. And if I might just very briefly, Mr. Chairman, comment that in conversations with colleagues at the NARUC meeting, there's a very strong consensus that there's a desire with this initiative on the part of the FERC to basically preempt the state's regulatory authority in these matters. That is, as NARUC has pointed out in their comments, very problematic to us. I completely agree with Mr. Rosequist's analysis in terms of what this first round of comments ought to look like. But I think we need to be at the table from day one with our comments, and then would simply add that keep in mind Commissioner Christie has specifically requested that we address in a separate document the question of PURPA and its impact, those rules and their impacts on Montana. So I would strongly suggest again that we segregate those two efforts, that our comments with regard to the advanced NOPR deal almost exclusively with the concerns raised in the NARUC comments, and that we then work with staff to craft a separate document to send to Commissioner Christie and his colleagues with regard to the PURPA rules, Mr. Chairman. So I would move that we in fact authorize staff to issue comment with regard to the advanced NOPR.
I second the motion, Mr. Chairman.
All right, so we have motion that's been seconded. Discussion?
Mr. Chairman.
Commissioner O'Donnell?
Yeah, I just wanted to add with the caution that it may be entirely redundant to enthusiastically support all the comments of the Vice Chairman. I think we need to be involved, and as two FERC commissioners have made clear to us that they value the state's information on this, which I think is incredibly healthy, that it's a bottom up, not a top down approach, Mr. Chairman.
Thank you, Commissioner O'Donnell. Additional discussion, Commissioner Fielder?
Yes, Mr. Chairman, thank you. I'd just like to add that I do concur with Mr. Rosequist's recommendation that the comments be brief and on point. I don't think we should shy away from setting the record straight, though. If there's something in the record that is incorrect about this commission's actions, I think that should be set straight.
Additional discussion? I would just reinforce the point you made, Will, about the relevancy of some of the QF developers' comments in this document. And I would say that when reading those comments over the weekend, notice that maybe those comments that were being submitted are far afield for what the FERC proposal is. Additional discussion? Additional discussion? Right, all those in favor of the vice chair's motion directing staff to file comments, signify by saying aye.
Aye.
Aye. All those opposed, same sign. Seeing no opposition, motion carries unanimously. And with that, we are through our work session items for today. I would just note for the record and for the public's information that we will not be having a business meeting next Tuesday. So our next business meeting is scheduled for 9:30 a.m. Tuesday, November 30th. And with that being stated, and there being no further business to come before us, I adjourn this meeting.